Okay, part two. Next part of case briefing, we went through our facts and we went through our procedural history. The next thing we really want to deal with is our issues. And until you get the right issues, you cannot, you know, capably formulate your brief. Okay, so don't confuse questions of fact versus legal issues. So, questions of fact are to be decided by the fact finder. The fact finder is usually the jury. Sometimes you don't have a jury, and then the judge is the fact finder. So, they say things like, were they speeding? Were they negligent? Those are like questions of fact that are determined by the fact finder. And when you are on appeal, the appellate courts always defer to the trial court for determination of issues of fact. So if the trial court found the defendant guilty in a criminal case, they're like, okay, well, I can't change that. Now I can change what a jury hears or something like that, so that maybe if a jury hears different things, they might make a different decision, but they cannot say, okay, he's not guilty. Or if they say he was speeding, they're not gonna say like, "All right, well, they're wrong that he was speeding." It has to be something else that the appellate court is hearing. Okay? So we're never when we're writing our briefs and memorandum of law, we're never looking for questions of fact. We're always looking for the legal issues that the court is going to answer. Okay? So it's a legal issue, it's a question of law, and we do include part of the facts in our legal issue, but the holding or the conclusion will be on a legal issue. Um, okay, so questions of fact are determined by the fact finder. Questions of law, if we're in a trial court, a judge determines the answer to that, and on appeal, it would be your panel of judges. So that's who answer those, and those things can be appealed. Okay, whether a judge or a panel of judges made a mistake. So when you're looking for our issue, when we're trying to write out our issue, it's like, how does this rule of law apply to our facts? Our rule of law can be any primary law. It can be a code section, a case, a constitution, blah, blah, blah. And then every part of a legal rule, they call all the steps necessary are called elements. A couple of weeks ago, we talked about the elements of assault, right? It was under, I don't know what it was. When it was apprehension of being hurt, I remember there were all those sorts of different legal requirements. Okay, so sometimes parties say, we disagree when they're on appeal. We disagree with what the definition of the law is or what the components or elements of this are. So think of the forfeiture by wrongdoing doctrine. Okay, what law applies, right? Is it this code section or is it the common law doctrine? Okay, so that's one way of kind of looking at what the one question of law that might be before the court. What is the applicable law and what are the applicable components of the elements? Sometimes do the facts fit the rule? Okay, we have four elements. Do all of these facts fit? Fit, and does the law apply? Is the application consistent with other cases? We have other similar cases. How was it applied by courts in the past? And you have to make that factual application consistent. All right. So sometimes, and we're in Stasky now, you're looking at a case where they're trying to figure out a definition. What does this law, what are the words, or what is the meaning of a word or phrase in the law? We see this a lot in, statutes, Constitution. What does due process mean? What what do words in a statute or a other law mean? Okay, it's one of the most common types of issues that courts deal with. Okay, so in a statute which allows court to divide property in a divorce action, is a home included in the definition of property? So what is the definition of property? So that's kind of a definition type one. Okay. Application of a common law doctrine. Here's one. A common law tort of false imprisonment says there must be a confinement. So what is a confinement? Somebody leaves somebody in a room, but the door's not locked. Is she confined? That's a definitional issue. So does that mean that they can't get out, or does it just mean that they're put in a room? I'm on an airplane. Am I confined? Probably. So that's an example. Another type of legal issue: do the facts fit? The rule of law is established, but we want to know, do these facts fit so that the rule will apply? Okay, does failing to shovel snow off of someone's sidewalk, is that negligence? If your insurance policy requires prompt notification of an accident and you wait 30 days to tell them, is that prompt notification? Some person has, kind of some back pain, and then they have a accident and then they need back surgery. Did that accident cause, the need for back surgery, right? So those are factual. Do the facts fit? Okay. Consistency is one rule of law consistent with another. So this is Peterson, right? We have two rules of law. We have the code section and we have the common law doctrine. They have different requirements. Okay, so they're kind of inconsistent. So does one rule of law actually contradict the other rule of law? And a lot of times we have combination. So does bingo fall within the definition of illegal gambling? So we have to find out what illegal gambling means. That's a definitional issue. And then it combines with, do the facts fit? Okay, so when you're reading a legal opinion, remember that it's very rare that there's only one issue. Some or deal with the underlying facts, and a lot of them are procedural. Some of them are substantive with regard to like what the law is or the application of the law. So, for shorthand, to get there quickly, look in the syllabus. You can find your issues there. Sometimes they say the issue before this court is very, very easy way to find it. Questions presented is another way to find it. If you look at the holding, it gets to that. And then sometimes you write the issue, and then at the end of the opinion, they're like, well, since we answered this question, the other one, we need not address that because it no longer applies. It's moot, M-O-O-T, moot. So sometimes you're writing your issue, and then in your brief, you're like, oh, that's kind of a big anticlimactic thing because they never even got to it. Okay, so it's a legal issue if there is a disagreement between the parties over the meaning or application of a law. You have specific facts, and then someone is claiming error by a judge, either at the trial court or by an appellate court. Oh, see, things. Issue before this court is, appellant argues, the court will determine. All of those things are ways that you can cue you into, they're talking about the legal issue here. When you are writing your legal issue, make sure you include the rule of law, the facts, and combine the two. So if you look on page 100 of that, it kind of gives you the legal, some examples of it. Okay, when this occurs, does the rule apply? Something along those lines. Did the court err when they made this ruling when the facts were X, Y, and Z? That is your way to write an issue question. Okay, holdings is the court's answer to the legal issue. And when you're writing out your holding, you're going to say, yes, the court erred when it did blah, 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 blah. That would be kind of the way to write it. So you have to have the same essential components that we had for a complete statement of a legal issue. So you want a reference to the rule of law, and then the key facts that concretely give rise to the controversy. But the holding is not a question, it is an answer. So do all that. So your homework is going to be writing out some of the holdings in the cases in the back of the Statsky text. Okay, so reasoning and analysis. This is like the super more detailed part of it. So the court is going to talk about things, and why this is, why they reached the holding. So if it's a definition issue, they are going to give you the corrective definition. They're going to be, might be based on legislative intent. It might be based on prior cases, and they're going to go through the prior cases or how they got there. If you look on page 114, they give you ways that a court's going to determine a meaning of a word or a phrase in a statute. So plain meaning is what they look to first. What is the ordinary definitional meaning of a word? Sometimes they just go to Webster's dictionary. Sometimes in a statute, they'll have a separate section which defines terms. So they'll go there. They'll go to case law, legislative history. Legislative history is a documentation of how the law came to be. So you'll have things like prior drafts of the bill, or maybe testimony in Congress when they were trying to get the bill passed. A lot of times they look to the public policy that is meant to be served by the law, and if one interpretation violates that public policy, they won't use that. Other statutes, persuasive authority, there's a bunch of different things that they look to when they're trying to figure out a meaning of a word in a statute. But really what you'll see the most often is this: what's the plain meaning? Yeah, and they'll look to see how this word has been interpreted in prior opinions for precedent, right? And the public policy. If you're in a do the facts fit, they lay out the rules or elements, 1, 2, 3, 4. They look to the facts and then see if they apply. So if we were looking at that code section in Peterson, right, we needed that they killed someone for the intent that they didn't testify. And then safeguards of reliability and interest of justice. Those are the 4 things, and they have to determine that. Sometimes they look at prior cases with similar facts if you're doing kind of a common law issue, and apply the rules. If the facts in prior cases are different, then they won't apply the rule. So that's kind of how they do it. Consistency. Are they consistent, or is there a conflict? Obviously, in Peterson, there was a conflict. There were different requirements. Sometimes if it's a federal versus a state law that are inconsistent, the federal rule will apply. State law statutes will control over case law. Constitution wins over a statute. As we learned, a court rule will win over a statute when it is related to procedure. We learned that in the Peterson case. Now on page 121, there's a whole set of rules that you should guys go through on when it is, what a court does when laws are inconsistent. Okay. Key facts. Let's see. So remember back to the key facts. This is kind of how, if they are looking to particular facts when they're making the reasoning, that's one other way that it is a key fact. All right, on to chapter 9. So sometimes, and remember, like when in Peterson, they're talking about that the prosecutor, said, "Oh, I wrote the law," and kind of, there's a little dig to the prosecutor there. That's what we call dictum. It's a remark or observation that is unnecessary, and it is not precedent. It is not relevant to the holding or the analysis. So they're just talking. They're just saying. I remember reading this one case once where they were talking about duty, legal duty, and the judge was like, "We all have duties. We all have duties to, like, turn off the faucet when we're brushing our teeth and to recycle our garbage and whatever, but that doesn't mean that it is a legal duty." So that was kind of a remark or observation. It's not saying, "Oh, we all have to turn off the faucet while we're brushing our teeth." Um, it's not an imposed law. So it's a remark or an observation. Also, they call it obiter dictum is the full phrase. If you're using it in the plural sense, we call that dicta, not to be confused with the famous Chicago coach. And it's never going to be precedent. Maybe they can look to it as persuasive authority, but it's never going to be mandatory authority or precedent. Okay, commentary. So also when we're looking and we've talked about these other opinions that are written by judges that are included in the opinions. So the dissent, when a judge disagrees with the majority decision and writes a separate opinion. That is fine. You can write a dissent, but that is not precedent. Okay, it's not mandatory authority. They're just hoping that at some point, maybe someone else will read this and apply some of the reasoning because they want to, not because they have to. A concurrence, remember, a concurrence is when the judge agrees with the outcome, but for different reasons, and they write that opinion, a concurring opinion. So again, not precedent. None of them have precedential value. Disposition. So don't confuse holding with disposition. When you're writing your legal brief, you can add disposition, it doesn't hurt anything. But the holding is the answer to the issue question. The disposition is what happens as a result of the ruling with regard to what happened before. Let me start that over again. How it affects the prior judgment. Okay, so affirmed, it agreed with the result below. Okay, it's like, okay, yeah, we're just going to let what happened stand. All good reasons, perfect. Okay, reverse, we disagree with what happened below. We're changing that result. Okay, reverse and remand. So reverse is the disposition, but then they kick it back to the lower court to proceed based upon this legal ruling. So Peterson is an example of that. They reversed that decision. They've remanded it back to the trial court for those hearsay statements to be admitted into evidence. Modified, they might partially change the results. So kind of a split. Sometimes they say affirmed in part and reversed in part, but those are, your main ones. So make sure you don't confuse this with holding or conclusion, and you understand what those things mean. Oh, yeah. In this chapter, they talk about the difference between a composite brief and a thumbnail brief. We're going to be working on comprehensive briefs, but for your own edification, you can do a thumbnail or a quickie brief if you just want. Maybe you're only interested in one of the issues in the case, so you don't have to go through all 6 of them. Maybe you just, if it's not about the procedure, you eliminate the procedure. Maybe you just do facts issue holding without, a big, full, long analysis. So just an option. This is back to Hamey's. I find this helpful. Sometimes I have students who get very overwhelmed with our final project. So just some tips on how to approach a project that just seems too hard. And it's not just in the legal world, but in any world. So, when you have a project, make sure in your firm, what is the assignment? What do they want you to do? Whether it's research or whether it's summarizing documents, what do they want? And what is the final product they want? Do they want a memo? Do they want a spreadsheet? Do they want a something on a mounted for evidence or something like that, a chart? I don't know. What do they want? And when do they want it? Um, so that you can budget the appropriate time for it. And then this is what I always do. I just make a list. Get all the big projects into little projects. What do we have to do and in what order? And then once you have your list, you can do the easy parts first and then they're off your list. Okay. And then I know that the hard parts are like, oh, and it happens to me every day. I have things I don't want to do. And I try to get all my easy stuff done. But then you just have to make a decision and dive into the hard parts. And you don't have to do like the greatest job the first time you try it. Just start it, and then once you get focused on it, you'll see you've made progress on it. After you've kind of made headway that way, double check, go back to the beginning. Am I still on the right track with the assignment? Sometimes you go down a rabbit hole and you've looked at things that maybe are not what the original assignment are. So go back, make sure you're still on the right track. Okay, then, finish your writing, finish your whatever your work product is, print it, after it's all your first or second draft is done, print it out. Sometimes it's easier to print it out than to look things on a screen. Make sure it's logical. Make sure there's no typos. Make sure your organization makes sense. And I always think it's helpful to have somebody else proofread it. So, try not to leave things to the absolute last minute, but just have somebody else look at it. In a law firm, you have a coworker who can look at it. An assignment, have somebody in your house read it. Even if they don't have any legal background, they can just tell you if it makes sense. They might say, like, what does that mean? And then you're like, yeah, this doesn't make sense. Or like, you're saying the same thing 3 times because you've looked at it so many times and you just don't even see that error. Okay. And try not to overthink it. So that's that. Make sure to watch the lecture on the Miller case and do all your work. And I will chat with you next week.